Hello, my name's Mark Roberts and I'm a partner in the Life Sciences Group at Davies Collison Cave. You might be aware that from the 15th of April 2013, most of the provisions of Australia's new Raising the Bar intellectual property legislation are going to come into force. Today I'm going to discuss some of the major implications of the new law with my partners Caine, Wolnizer and Chris Jordan. Caine is the head of the firm's Pharmaceutical Patents Group. Michael's been heavily involved in consultation with IP Australia in relation to implementation of the new law in Australia. Now Michael, I was wondering if I could ask you the way in which the new law is going to in fact raise the bar for patent applicants in Australia.
Well, Mark, the main changes relate to an increase in the standards for patentability and the standards for patent specifications. So an applicant will now be required to provide a more detailed description of their invention, and they'll also need to provide more evidence in their specification that their invention works and achieves the objectives. And for this reason, I think it will be more important than ever that applicants get their applications professionally drafted. And not only that, but the examiners have now been provided with more tools at their disposal to reject those borderline applications where there might be some doubt as to patentability.
Okay, and can you give us some ideas about actions that applicants might be able to take in advance of the introduction of the new law?
Well, the main action that they can take would be to file their applications with an examination request on or before the 12th of April 2013. If they've already filed their patent applications, then they should make sure that they've requested examination by 12 April 2013.
And what impact is that action going to have?
Well, if they take that action, their applications will be judged against the more lenient provisions of the current Act.
Okay, thanks very much, Mark. Michael Wolnizer is a trademarks expert and manager of our firm's trademarks business unit. Now Michael, I was wondering if you could tell us what the major implications of the new law are going to be on trademarks.
Mark, the biggest changes for trademark are actually procedural in nature, and in particular the way oppositions are handled before the office.
Okay, so what sort of procedural changes are we talking about?
First of all, a number of grounds to get an extension of time to file a notice of opposition have been removed, and a number of time frames to do things before the Act have been shortened significantly. And the most notable being the time frame to file a notice of opposition has been shortened from 3 months to 2 months. The way an opposition is filed is also being changed. An opponent will now file a notice of intention to oppose, and then 1 month later it must file a statement of ground of particulars, which sets out each ground of opposition and why it's relevant and what it's based on. That is a big change. So at the moment, an opponent files a notice of opposition with all grounds that may be relevant, and it develops its case as it prepares its evidence and as it prepares for hearing. So all that work will have to be done at the outset of an opposition now, so it's going to be more costly at the outset for an opponent. Once a statement of grounds is filed, an applicant has a new requirement to file a notice of intention to defend the opposition. And if that's not filed, the application lapses. So lots more changes, but they're the key ones.
Okay, thanks very much for that. Pleasure. Chris Jordan is an IP litigator and manager of the law group at Davies Collison Cave. Now Chris, I wonder if you could tell us what the simplest thing that the owner of an Australian trademark can do to try and prevent counterfeit goods coming into the country.
Mark, the simplest thing an Australian trademark owner can do to stop counterfeit goods coming into Australia is to file a notice of objection with the Australian Customs Service. It's a relatively simple and inexpensive procedure. It means that customs will stop counterfeit goods coming into Australia at the border.
Okay. What's the impact of the new Raising the Bar legislation going to be on the customs seizure provisions?
Well, they're going to be much more streamlined and user-friendly. Quite often, when counterfeit goods are being imported into Australia, the rights owner is not going to have to do anything to ensure that the goods are seized and destroyed by customs. Also, customs is now able to provide rights holders with a considerable amount of additional information, particularly information about who has sent the goods to the Australian importer. That's going to mean that rights holders are going to find it easier to enforce their rights against counterfeiters at the source.
Okay, so pretty significant changes.
Yeah, significant and good for rights holders.
Excellent. All right, well thanks very much.
No worries, mate.